Okay, well, it's 6 minutes and we've got 84 participants, which is really good. So let's make a start. So thank you all for coming. Some of you will know me. My name's Diana Kirsch. I'm Associate Dean Enterprise here at Herts and also Director of Pro Bono. And I'm going to hand over to Penny Carey, who is Dean of Hertfordshire Law School, who's going to introduce our panellists.
Thank you so much, Diana, and welcome everyone. And thank you all for attending this evening. As you can imagine, we're absolutely delighted to be hosting this panel event for LGBT History Month. And this event is a celebration of the crucial role that lawyers have played in fighting for LGBT rights through the courts. And this evening, we'll hear from speakers who've been involved in some of the landmark cases of the last 2 decades. It's really shocking to remember how different things were only 20 years ago. The notorious Section 28, which prevented schools from talking positively about homosexuality, was only repealed in 2003. Gay marriage was legalised in England, Wales and Scotland in 2013, but the first gay marriages could only take place in Northern Ireland just over a year ago in January 2020. At Hertfordshire, we hope that some of our students will also become the type of lawyers who will make a difference. We encourage all our students to take part in pro bono projects, and we hope that this will instill a passion for volunteering that will stay with them throughout their careers. We're really proud to support LGBT History Month. We are a very diverse law school, and we strive to create an inclusive environment for all staff and students alike. I'm particularly delighted to announce that next month, we'll be launching an LGBT+ Law Clinic with the support of lawyers from the Law Society's LGBT+ Lawyers Division, providing free advice to the LGBT community on a range of issues, including family, employment law, and housing law. So I'm now delighted to welcome our speakers, all of whom have played a significant part in enhancing LGBT rights. There will be time for a Q&A at the end, and if we would ask that you please add your question to the Q&A chat box, and we will do our best to answer as many of them, or to ask as many of them as we can. So if I could welcome first Paul Staddon. Paul had a successful career at the bar spanning over 30 years before retiring last year. How sensible, Paul, just before the pandemic. Paul acted for the tenant in the case of Mendoza and Gaidan in 2004. In this case, he successfully argued that the gay partner of a deceased statutory tenant should be treated as if he were the spouse of the deceased, thereby giving him the right to inherit the statutory tenancy in accordance with the Human Rights Act. Our second speaker is Casserley, who is a barrister at Cloisters Chambers. Catherine specialises in discrimination and equality, employment and human rights law, and in both private and public law. She appeared in the Predian Hall and Bull case, where she successfully represented a gay couple who were prevented from occupying a double hotel room by its owners. This was the first case of its kind, which reached its successful conclusion in the Supreme Court. Our third speaker is Robin Allen QC, who is a leading equality law barrister, also based at Cloisters Chambers. He has twice been Chambers and Partners Employment Law QC of the Year. Robin has given evidence to parliamentary committees on the technical aspects of proposed legislation, such as the Marriage Same-Sex Couples Act 2013, and on behalf of the Bar Council. He advised the European Commission on the content of the first 2 key equality directives. He represented Mr. Lee in the Supreme Court against a bakery owned by evangelical Christians who refused to bake a cake with support gay marriage iced on top. He also represented the Equality and Human Rights Commission in the Predian Hall Hotel case. And our final speaker this evening is Raza Hussain QC, who is a leading public law barrister based at Matrix Chambers, specialising in immigration and human rights. He appeared in the HJ Iran case in the Supreme Court and successfully argued that his Iranian client should be granted refugee status. Asylum was originally refused on the basis that his client could be reasonably expected to conceal his sexual identity in order to avoid persecution in his home country. The landmark decision legally recognised that a gay person is entitled to live freely and openly in the same way that a straight person can. So thank you all again very much for giving up your time this evening. I'm delighted that we have so many people here, and I would now like to hand over to you, please, Paul, to kick off the proceedings. Thank you.
Thank you very much, Penny. I'm going to talk a little bit about the case of Gaiden and Godin Mendoza, where I appeared at first instance in the West London County Court on my own, and then in the Court of Appeal, again on my own, and then finally in the House of Lords, where I was led by Rajinder Singh QC, now of course in the Court of Appeal. I joined the bar in 1976 and retired almost exactly 2 years ago, so a little bit over 40 years. And by the time this case was heard, I was an expert in housing law and landlord and tenant generally, but knew absolutely nothing about human rights law. But I was a very experienced advocate, and I was trusted by my instructing solicitor, Oliver Fisher and Co., who then, as now, are the go-to firm solicitors in West London, indeed, probably all of London. Of course, when the case was heard at first instance, the Rent Act had been repealed for about, well, over 10 years, and that so there could be no new protected tenancies. And with protected tenancies came the right to a controlled, it was actually called a regulated rent, which was lower than the market rent. And the new regime for protection of tenants was less good, and it was certainly less good in as much as you paid a market rent. But there were still people who had Rent Act protected tenancies, those which existed before 1989 when the Housing Act 88 came into force, and also those who were the spouse of a deceased Rent Act statutory tenant. They could also succeed to a statutory tenancy with all the advantages which went with it, a higher degree of protection, and indeed less than a market rent. And I'm going to read to you, because I can't remember it, what it is that you need it to be. So this is from the much amended Rent Act 1977. It's Schedule 1, and you start off with paragraph 2. The surviving spouse, if any, of the original tenant, if residing at the dwelling house immediately before the death of the original tenant, shall, after the death, be the statutory tenant if and so long as he or she occupies the dwelling house as his residence. Now, listen carefully. For the purposes of this paragraph, a person who is living with the original tenant as his or her wife or husband shall be treated as the spouse of the original tenant, as his or her wife or husband. And where that didn't apply and someone else was living as a member of the original tenant's family, they would succeed to the less good assured tenancy. And it was most important for my client to be held to be a Rent Act statutory tenant because, to be quite frank, he couldn't afford the rent if he had to pay a full market rent, which to the best of my recollection was a pretty decent flat in the Earls Court area. And a little bit about the background of them. Mr. Walwyn Jones, my client's deceased partner, had been the Rent Act tenancy before his death, and he had worried about my client's position. And he had gone to see my solicitor to ask for some advice about what might happen. And the advice had been pretty conservative, pretty negative. At that stage, the leading case was Fitzpatrick, and it held that a gay person was a member of the family, could get an assured tenancy, but alas, wouldn't be a Rent Act statutory tenant. But there was a sliver of hope. Lord Slynn, who I think had sat in the European Court of Human Rights, was on the panel of the House of Lords, and he expressed the opinion that the coming in of the Convention on Human Rights might change everything. And those instructed me, following the death of Mr. Walwyn-Jones, Mr. Mendoza came to them and they got legal aid, and following the advice of my colleague in Chambers, Gerald Wilson, but I was instructed for the trial. And so it went to court. And may I say this? My opponent in that case was as ignorant of human rights law as I was, but neither of us quite as ignorant as the judge. And in fairness to him, he didn't get much help from us. And it was a very rapidly developing area of the law, and there were very few good textbooks and very few experts. And certainly we weren't ones. We were housing experts. But the judge at first instance, he was a very honest man, even if he was clearly unaware of the ramifications of the act. And he ended up being convinced by my opponent's argument that, the right to protection of your home amounted to the right not to have government-sponsored stormtroopers coming in and dragging you out. And that really, it had nothing to do with two individuals where the state wasn't directly involved. But he found facts as good as they could be. He found that my client and his partner had lived together since 1972, had moved into the flat together in 1983 when the partner had taken the tenancy in his name. They are a well-known and well-respected couple. They were very social, and we had about a dozen witnesses who, all in their own words, yes, they actually wrote their own witness statements for once, and it showed, said how well they knew them and could testify to the enduring strength and the nature of their relationship. And thank goodness the judge was very honest. And this is reflected in the judgment of the Court of Appeal, where it said that there was overwhelming evidence that Mr. Walwyn-Jones and Mr. Mendoza were in a very close, loving, monogamous relationship characterized by long-term sexual activity. The judge found against us, but, and of course we appealed. And by the time we got to the Court of Appeal, the case had gained a deal of publicity, and I was overwhelmed with unsolicited help from the LBG community. Academics put in their articles. Outside court, we had Martin Bowles, QC, there to offer his support. He had only recently been outed in the News of the World or the Sunday People, as happened in those days. And we had the press there in Joshua Rosenberg. And as I say, by the time we got to the Court of Appeal, we had all the facts in our favor, and it's just the tricky business of the law to deal with. And I was absolutely delighted when I got to court to find out that Stonewall had instructed Rabinder Singh on an amicus brief to intervene. And that turned out to be extremely useful. And the Court of Appeal, they couldn't have been kinder to me. They allowed me to jettison all my hopeless points and with some encouragement, I argue that our real case was, of course, under Article 14 and making the obvious point that to afford a statutory tenancy to the survivor of a heterosexual couple was only an assured tenancy, the less good one, to a homosexual couple constituted discrimination on the grounds of sexual orientation. And in that context, Article 8, the protection of your home, and Article 1 of the First Protocol, protection of property, were merely gateways to the application of Article 14, the non-discrimination grounds. And that's the context in which the article took effect. My opponent argued that there was no gateway here, as my client still had a home, albeit under a secure tenancy, and more boldly, that the convention did not prohibit discrimination on the grounds of sexual orientation, and that there were perfectly good policy arguments for that. Well, Rabinder Singh was able to cite, thankfully, numerous international conventions, outlawing sexual orientation discrimination. And he was able to give a short shrift to the judicial deference argument, which was advanced by pointing out that if a government wanted to discriminate against what we now call a protected group, it better have damn good reasons and damn good evidence to support such discrimination. And so the Court of Appeal clearly wanted to help. It was as if they were joining that march over the bridge at Selma. And of course, you must remember that they would have all been idealistic students at the time of the US civil rights movement. And so they were anxious to do the right thing, and we succeeded. It dealt with the construction point, that is, the words as his or her wife or husband, to mean as if they were his or her wife or husband, and holding that the words achieve what is required in the present case and does not have to open the door to lesser relationships, brother and sister, if you like, because those relationships did not enjoy marriage-like characteristics, and which the judge found to have characterized the relationship in our case. And the other side appealed to the House of Lords. Don't ask me why. Now, by this time, Stonewall had dropped out, and we thought it wise to get Mr. Singh on in as our leader, and the landlord instructed a leader as well. And I shan't name her, so I don't wish to be unkind. The taxi rank principle that barristers have means that you make arguments that you don't personally hold, and I think that she probably did in this case. And so we came to the first mistake by the other side. Lady Hale, only just appointed to the bench, to the Lords, raised the issue that her daughter was gay and that she herself, Lady Hale, was a member of Stonewall. And was there any objection to her hearing the case? My opponent said, wait for it, there was no objection. My goodness, what a mistake. And also at the last moment, we had another intervening brief, this time from by the Treasury Council, who came to argue on, I think, for the Secretary of State for Housing, anyway, some Secretary of State. And so the arguments began. The landlord argued that the relationship, only a relationship where there was a possibility of children, should enjoy statutory protection under the convention. There is a relevant distinction between heterosexual partnerships and same-sex partnerships. The aim of the legislation was to provide protection for the traditional family. Same-sex partnerships could not be equated with a traditional family in the traditional sense. Same-sex partners were unable to have children with each other, and there was a reduced risk, a reduced likelihood of children being part of such a household. Are you serious? Said Lady Hale, in exasperation, or worse to that effect. What about infertile heterosexual couples? What about very old ones? Think how such a concept would have changed the course of English history. In his speech, Lord Nichols dealt with this argument saying, security of tenure for the survivor, and I'm sorry, I'm going to have to read this, of such a couple in the house where they live is doubtless an important and legitimate social aim. Such a couple share their lives and make their home together. Parliament may readily take the view that the survivor of them has a special claim to security of tenure, even though they are unmarried. But the reason underlying this social policy, whereby the survivor of a cohabiting heterosexual couple has particular protection, is equally applicable to the survivor of a homosexual couple. A homosexual couple, as much as a heterosexual couple, share each other's life and they make their home together. They have an equivalent relationship. There is no rational or fair ground for distinguishing one couple from the other in this context. And this being so, one looks in vain to find justification for the difference in treatment of the couples. Such a difference in treatment can be justified only if it pursues a legitimate aim, and there is a reasonable relationship of proportionality between the means employed and the aim sought to be realized. And here the difference in treatment fails at the first hurdle, the absence of legitimate aim. None have been suggested by the first Secretary of State, and none is apparent. Can I be heard, may I ask? Is anyone still there?
Oh yes, Paul, we can hear you.
Sorry, it's just that I could just see Robin's face and no one else. And so the final issue became one of statutory interpretation. Could the words of the Act, man and wife, include same-sex couples? And Lord Nichols cut the knot. On the interpretation issue, he held that courts did not need to restrict their interpretive function solely to cases where there was some ambiguity. Indeed, he said there was no ambiguity there, but that it had to be read with the grain of the convention. And that being so, he did not bother to seek to apply additional words that the Court of Appeal had, but simply said that protection of paragraph 2 of Schedule 1 of the 1977 Act, that's the one we wanted, applied to homosexual couples as it did to heterosexual couples. Now, Lord Millett, who was also on the panel, persisted in resisting. He'd done enormous research into the origins of marriage. He was obviously rather cross it had been wasted, but he was the only dissenting voice. And so, happily afterwards, Mr. Godin Mendoza remained in the flat, and to the best of my belief, he's still living there. And how did this benefit my legal practice? Not in the least. I had one piece of advisory work on the implications of the decision for the Inheritance Act, but no follow-up. But was there a lasting benefit to me? Yeah. I'd actually done something worthwhile for once, something to look back on and be proud of. And so it's proved. And it's good that Gaydon and Godin Mendoza is still thought of almost 20 years later. Thank you.
Paul, thank you so much. That was a really, really interesting summary of the case and really interesting to hear your thoughts. Thank you. And I'm looking forward to some questions coming through. Yes, a virtual round of applause coming through from Robin. Quite right. Thank you. So on to our second speaker, Catherine. We're over to you now. Thank you. But you're muted.
Sorry, usual problem with unmuting. Yes, it's the story of the last year, really, isn't it? Thank you, and I'd like to thank you for inviting me to speak at this event. And it's great to be on a panel with everyone else as well. It's really interesting to hear the stories behind the cases. I'm going to talk obviously about Preddy and Hall and Bull and Ball, and I'm going to talk perhaps more about the county court case than I will about the Court of Appeal and the Supreme Court, all of which I was involved in. But I think sometimes the first instance decision is in some way that's really the story that people don't get to hear, perhaps, because you can read the Court of Appeal decision and you can read the Supreme Court decision. And I have the first instance decision if anyone does want to read it, and I will perhaps read a bit of it out to you because I think it's quite an interesting one. Before I start talking about the case, I was asked to say perhaps a little bit about how I came to the law and how I came to be doing this type of law. I have to say I have no lawyers in the family. In fact, I was the first in my family to go to university. But I did watch when I was younger a programme that some of you may have heard of called Crown Court. And I watched rather a lot of it. And for some reason, I decided when I was about 12 that I wanted to be a lawyer. And that's what I was going to do. Unfortunately, when I went to study law, I didn't really like it very much. I liked some of the law, but I didn't really like the fact that everyone around me seemed to be very interested in making a lot of money. So I took my degree and then I took myself off to a Citizens Advice Bureau and worked there for a year. And that's where I discovered that law could do more seemingly to make money, it could make a real difference to people's lives, I felt. And so I developed much more of an interest, I felt, in the way in which law could affect people, and it could also affect strategic change. So I have worked in trade unions, I've worked in law centres, I worked in the Disability Rights Commission, and then I came back to the bar, having previously done my pupillage, and spent a bit of time at the bar. And I practiced in discrimination and human rights. And in fact, that's what brought me to the Equality and Human Rights Commission and to this case, because I knew quite a lot of people who worked in the Equality and Human Rights Commission, and I do quite a lot of work with them. So that's where the circle squares, as it were. So turning to the case, Martin Hall and Steve Preddy were a couple who had entered into a civil partnership, and they had a dog, and they loved their dog very much, and they wanted a dog-friendly B&B to stay in. And they found one which described itself as unique because it had a really fantastic view. And it did. If you went on the website, it was, I think it was in Cornwall, and it had really spectacular views of the sea. But they didn't actually book online. They didn't use the booking form. They phoned up, and they weren't asked anything. In fact, it was, I think it was Martin who phoned up. They weren't asked anything about couple status. They just said they wanted a double room. And then they turned up. And when they turned up as a male couple, they were told that the rooms were only for married couples. And they said, well, we're in a civil partnership, so that's fine, isn't it? And they were told, no, by married couples, we mean different sexes. The hotel's owners were Christian, and they said that they only let double rooms for joint occupation to married people. And Martin and Steve had turned up a bit late. There were other people there going backwards and forwards, and they had to find somewhere else to stay, and they were pretty upset by what had happened. They felt that their relationship had been undermined. They had had a long drive from Bristol, and they were really upset by it. They were not crusaders, they weren't campaigners. They were just very unhappy about what had happened and the fact that they hadn't been treated properly. So they did complain to Stonewall. Stonewall didn't take the case up. So then they went to the Equality and Human Rights Commission. And the Equality and Human Rights Commission said, well, this is in breach of the, at the time, it was the Sexual Orientation Regulation. So this was 2000, and I think it happened in 2008. So it wasn't that long after the regulations had come in, so prior to the Equality Act. And what the regulations said was that, essentially it said that it would be direct discrimination if you were treating a couple in a civil partnership in a different way to a couple in a married relationship. You had to treat civil partnerships and marriages in the same way. And so the Equality and Human Rights Commission took the case on, and they instructed me. And the case, the Equality and Human Rights Commission pleaded the case. I had to make some amendments to it. The case was defended and funded by the Christian Legal Centre. And some of you may be aware of this because it's been involved in quite a lot of the cases that involve religion and belief. So they fund quite a lot of them. They've got quite deep pockets. And so, for example, the defence in the case was drafted by a QC. And it was, I would say it was litigated, certainly as far as the claimants were concerned, in quite an aggressive way. So to give you an example of that, I have to say I was only reminded of this when I looked back at my papers in the case. One of the things the claimants had done was they'd asked to move the trial window of the case. And that application had been unsuccessful. So the defendant's solicitors had written a letter about their costs directly to the claimant. So instead of writing to the Equality and Human Rights Commission, who they knew were on record, They wrote directly to the claimants, asking for the costs and threatening them with bankruptcy if they didn't pay. And that really upset them because they were worried enough about bringing the case and all the attendant publicity that might go with it without having that letter. And in fact, that formed the basis of us asking for aggravated damages because of the way that they did that. So the case rumbled on, as these things do. And when it came to the hearing, that was at Bristol County Court, and it was a hearing over 3 days. And outside the court, there was a sizable group, probably about 30 people, wearing T-shirts that said, "It's their home." And they were there to support the couple who ran the B&B. And they would stand outside the court every day singing hymns. So every day, my clients had to go past them. And that, again, that was pretty distressing for them, really. And one of the other things that happened is that in the witness statements, and again, you only see this when you go back, in the witness statements of the defendants, they'd suddenly referred to a Mrs. Preddy. So essentially what they were trying to say was that the claimants had set this up, which, it was the first time that this had appeared, and really wasn't the case. What I would say is that one of the things about any, particularly any new legislation, is that when you're looking for the ideal case to bring, organisations will have a strategic litigation strategy, and they'll have what sort of ideal claimants you want. And it sounds very cynical to say that, but everyone does it. But usually you don't get them falling into your lap. But I have to say that that Martin Hall and Steve Preddy probably were the ideal claimants. They were articulate. They were fantastic witnesses. They were also lovely. They were two of the nicest clients that I've had, really. And they were very involved in their case. They were very interested in it. They were alive to it, they were very aware of the importance of it as well, and they were very committed to it. As I said, the case went over 3 days. The arguments obviously were whether or not there was a breach of the regulations, but the defendants also were running human rights arguments, that this was a breach of their religious freedom. And obviously we were also arguing that the claimants had human rights that had to be respected as well. Their right to family life, home and environment, and Article 14 in conjunction with that. The judgment was reserved. And then when the decision was issued, we had won the case. And the judgment itself wasn't really long, actually. It was only 12 pages. And the judge accepted, certainly on the human rights arguments, he accepted essentially all of my arguments and just said paragraphs, I think 12 to something or other of Ms. Casserley's arguments, and that was it. He did start off with some paragraphs about how far society has come, and I'll read you the first paragraph because it just gives a flavour of what he went on to say. The first paragraph says, "In 1882, Her Majesty Queen Victoria opened a new court building. It is in the Strand, just at the entrance to the City of London. It was built to house the superior courts of this land, with the exception of the House of Lords. No one who enters can fail to be struck by the similarity of the Great Hall with the interior of those Gothic cathedrals with which this kingdom is so richly endowed. But if, before entering, you gaze upon the facade of the building, you will notice 4 statues." And he then goes on to talk about the 4 statues. And yes, So the judgment, a lot of the judgment is taken up with what those statutes are about and how far the law has come. And then the actual judgment is fairly brief because it's entirely in favour of the claimants. When it came to damages, however, the damages were quite limited. And he took into account the defendant's injury to feelings. And there is a reason for me saying that. Because judgment was in favour of the claimants. Claimants were delighted with the judgment. But the defendants appealed. And as you'll know from the fact that it went to the Supreme Court, defendants appealed, they lost, they appealed, it went to the Supreme Court, they lost again. When they appealed to the Court of Appeal, this is when Robin came in, and Robin led me in the Court of Appeal in the Supreme Court, and it was funded by the Equality and Human Rights Commission all the way along. But we looked at the judgment, and actually the judgment on damages was wrong. There was an error of law. And we initially cross-appealed, as you do if there's an error of law. And actually the judgment on damages was important to do that. However, the claimants have been subject to an awful lot of hate on social media and in the press. And it was really quite vile. And when that cross-appeal went in, it got even worse because they were subjected to abuse about money. And it was said that it was all about money. And because it was so bad, that cross-appeal wasn't pursued. And that was purely because they were getting so much hatred. And in fact, that hatred continued. And although I wouldn't say that they regretted taking the action, that hatred continued all the way up to the Supreme Court. I mean, they didn't really have to take part as such in the proceedings that carried on because they were simply the defendants to the appeal. And these were legal arguments that were really involved. But it was a really, really awful time for them when all they were doing was exercising their legal rights. So that was really awful. Yes. The other thing that I would say, when it got to the Supreme Court, there was a difference in view about whether or not it was direct discrimination or indirect discrimination, which I thought was quite surprising. The other thing, I think probably the last thing I will say, last but one thing, was that obviously the claimants, defendants to the appeal had been successful, as they had been all along. But they were not awarded their costs. And I think that's really interesting because not long after the decision in Predin Hall, one of the issues, and one of the cases that had been used, in fact, it had been used at first instance, was an American case that concerned a printer. And I mean, this comes up in the case that Robin will talk about. But it was an American case where a printer had been asked to produce some literature for a gay organisation and had said no, and that refusal was upheld. They were allowed not to do that. And that case had been used in Predin Hall at first instance, and it carried on being used. And not long after the Predin Hall decision in the Supreme Court, Baroness Hale gave a talk, I think it was in Dublin, where she indicated that she felt that there ought to be a form of reasonable accommodation in the context of religious belief. And I think that was indicative of perhaps a struggle that went on potentially with with Preddy and Hall. And I thought it was really interesting that the claimants, effectively the Equality and Human Rights Commission, didn't get their costs in that case. Because if you think about it, what was the reason for not getting costs in those circumstances? You know, I mean, the Equality and Human Rights Commission is a public body, and the appellant had lost, and it seemed like a very strange outcome. The only other thing I would say is, as I said, Martin and Steve were two of the nicest clients I've had. It's a case that I really enjoyed doing, not just for the legal aspect of it, but obviously it was a really important case. And I am friends with Steve on Facebook, and he's very amusing. So yeah, it was a pleasure to do, and I felt very privileged, actually. I felt really privileged to be been instructed in it, and very lucky as well. And I got to work with Robin, so that was even better. What more could I want? So thank you very much for listening.
Oh, thank you, Catherine. That was hugely interesting and very insightful, I think, as well, to think about. Sometimes I think we forget the impact that these difficult cases can have on the claimants themselves, and, you know, particularly with everything you were describing in terms of furore, deeply held views and opinions, and in terms of both aspects of it. So I'm sure someone will be interested to ask a question later on about some of the reasoning, maybe, or explore in a little bit more detail. But thank you so much indeed. And without further ado, Robin, I'm going to hand over to you on your Caribbean island to talk to us about the third case, and indeed anything else you wish to talk about in terms of this broad context this evening. Thank you. Robin, over to you.
Thank you very much, Penny. And for all those watching, the sad truth is that I'm actually about 10 miles away from the University of Hertfordshire, in another part of Hertfordshire, and not on a sunny island a million miles away. But anyway, that's my backdrop. It's a real privilege to be here and to be able to talk to you. I wish I could see all your faces. I want to start by saying, my guess is that you've logged on for one of three reasons. Two of them could overlap. One, because you thought you just generally needed to do a bit of extracurricular law work. And that's a good reason, because anybody who wants to be a lawyer is starting on a journey which frankly never ends, because it's a journey of inquiry, of engagement, and constant self-education. But the other two reasons, either because you're interested to see how LGBT rights have developed and what that means for you and the way that you live your life, or your friends do, or your clients do, or the third, and I hope the reason doesn't apply to many of you, because you're opposed to LGBT rights and want to listen about how people like our two previous speakers and Diana Kirsch and Penny Carey at the university talk about these issues, and perhaps want to get some insight about how you can respond to it. Okay, now a little about my journey. I was called to the bar in 1974, so a really long time ago. I thought I was going to be a politician, but back in the 70s, all the Labour Party meetings I went to then were full of people who smoked non-stop, and I hate smoking. It really irritated me, and I began to realize, just like Kath said, that I would never survive in that kind of milieu, but doing politics through doing law was a potential course going forward. And I worked with people in law centers and so on. Anyway, 10 years after I was called to the bar, 1974, in 1984, my wife was working in a law center in Camden, and a very good friend of hers and some others that I was closely connected with told me that there was an appeal that was going to take place in the Court of Appeal the next day, but unfortunately the barrister who was instructed in it couldn't deal with it. And the appeal was in a case called Simpson against Harrogate Borough Council. And it's kind of the foreword to Paul Staddon's case, because Miss Simpson was in a rent-controlled tenancy with a local authority. She was a lesbian in a very happy relationship, and her partner was the tenant. She was just there as her partner's other half. Very sadly, her partner died, and she tried to argue that she was entitled to succession, arguing that her lesbian relationship was equivalent to that of husband and wife. Now, if you get a brief like that with less than 24 hours to work out what you're going to argue, you have to do some fairly fancy footwork. And so I called up one of my wife's best friends, who's a co-author of a legal book with her, who was gay, wonderful woman called Angie Mason. And we sat down to try and think about who we could think of who were women who'd lived in gay relationships as husband and wife or as very close committed partners. And we got several different examples from literature. And then I went to court the next day armed with these examples, thinking I could try and persuade the court on the back of my great knowledge of literature. If you ask me questions later, I'll tell you a bit more about it, but I'm going to read from the judgment in that case, which was 20 years before Paul's great success. So it's worth just listening to this. The judge, who was in the lead, Sir Tasker Watkins, was a rugby player, and he got a VC in the Second World War. Anyway, this was his judgment. The council, that's Harrogate Council, contend that if Parliament had wished homosexual relationships to be brought into the realm of the lawfully recognised state of a living together of man and wife for the purpose of the relevant legislation, it would plainly have so stated in that legislation. And it's not done so. I am bound to say that I entirely agree with that. I'm also firmly of the view it would be surprising in the extreme to learn that public opinion is such today that it would recognize a homosexual union as being akin to a state of living as husband and wife. The ordinary man and woman, neither in 1975, when other relevant legislation was passed, nor in 1984, would, in my opinion, not think even remotely of there being a true resemblance between these two very different states of affairs. That is enough, I think, to dispose of this appeal, which for the reasons I've provided, I would unhesitatingly dismiss. Well, there you go. This proves something to all of you, which is the world changes. That was 1984. And now, for some years, we have the recognition of same-sex marriage in this country. And whilst I didn't change the minds of those judges, I was able to make an argument which later was developed much better and with greater tools, because the advantage of the Human Rights Act, by Paul and by Rabinder Singh in due course. And slowly, bit by bit, that led to, first of all, civil partnership, and then in Great Britain to an arrangement of same-sex marriage. Now, having lived through the experience of working with Kath, which was terrific, on Bull and Bull and Hall and Preddy, I was asked in 2014, so that's 30 years after I first worked on that case, to try and take on a rather related issue in Northern Ireland. Now, I should say I've done a lot of equality law from the time of Miss Simpson's case against Harrogate, and I'd been incredibly influenced by the life stories of people who had suffered through the discrimination and bias and prejudice. Just a small snippet of history. When Miss Simpson took her case, some person in Harrogate thought it would be fun to light a rocket and put it through her letterbox while she was living in the flat. This is really scary stuff. And I'd also listened to Kath describing and been party to some of the ghastly things that had happened in pressurizing Mr. Hall and Mr. Preddy in their piece of litigation as well. Now, the story of the case that I've been asked to talk about is a bit different. My client was a Mr. Lee, a gay man living in Northern Ireland, and he was involved in a campaign to try and get the Northern Ireland Assembly to introduce laws to permit same-sex marriage in Northern Ireland. And the campaign had some success. It actually got more votes for it than against it in the Northern Ireland Assembly, but not enough for it to become law, given the nature of the message involved, or the litigation, the legislation that was needed. And that's to do with the special constitutional arrangements in Northern Ireland. However, he was clear that there was some progress, and an organisation that he was involved in decided to have a little small celebration amongst the gay community in Northern Ireland to just keep their spirits up and keep them going. And he was invited to a party to celebrate this. And he thought it would be a lovely idea to bring a cake along to this party. And so he went off to a good baker in the centre of Belfast, and which he knew about. He'd been to previously to buy cakes, and he picked up a leaflet which showed that they would ice a cake to make it into a celebratory cake with any particular message you liked. They gave various different examples of the sort of things they'd put on cakes in Northern Ireland in this shop. It showed witches riding on broomsticks for a Halloween cake. There were cakes for football club derbies. There were birthday cakes. There were holiday cakes. There were marriage celebration cakes. There were all sorts of different things that were there. And he went in with a graphic that he'd knocked up himself with a picture of Bert and Ernie from Sesame Street, and underneath it said, "Support gay marriage." He went in, he handed over the graphic, and it was accepted, and he paid his money, £35, I think it was, for the cake to be iced in this way. He knew nothing at all about the bakery. It happens that Asher's had given the name of the bakery, had taken its name because the owners of the shares in the limited company called Asher's were evangelical Christians. They were from the Presbyterian community in Northern Ireland, and they knew that in, I think, Exodus rather than the first book of the Old Testament, there's a description of Asher's making dainty cakes and laying them before the Lord in the temple in Jerusalem. And that's where the name came from, but nobody knew that, certainly amongst Mr. Lee's friends, and it wasn't advertised as a fact in the bakery. Anyway, the owners of the bakery had a think about this over the weekend. And because the position of the Presbyterian community in Northern Ireland, the evangelical Presbyterian community in Northern Ireland, is that marriage is the union of one man and one wife, one man and one woman, they thought that this would be effectively a sin for them to let their business print this image. And so over the weekend, they decided they would return the money and reject the order. And that's exactly what happened. Now, that led to the Equality Commission for Northern Ireland supporting Mr. Lee in a piece of litigation based on two grounds. First of all, saying that he'd suffered discrimination on grounds of political opinion and also on grounds essentially of religious views. And in the course of the litigation, I acted from the very beginning all the way through to the Supreme Court. The first time it came up in in front of presiding District Judge Brownlee in a Belfast court. It was a pretty strange experience because just shortly before the hearing, the evangelical Christian community in Northern Ireland hired what's called the Waterside Hall, and some 2,000 people, I think it was certainly well into the thousands, filled the hall, and there was a mass praying for Mr. Lee to fail in relation to this litigation. I think it's the only time that it's ever happened that something like that has occurred in many cases I've done in this field of law. Anyway, that led to many people wanting to be in court, and we were actually given the largest court in Northern Ireland for the case. The dock was so large that an entire class of women or young girls from a local school who'd come to watch the case could fill the dock. It was the largest court suitable for terrorist trials that was actually used. Quite something for a case about a cake. And the case went on, and it was concluded that the MacArthurs, who are the owners of the bakery, in particular Mrs. MacArthur, who had both taken the order and conveyed the message that they would not go forward with it, had taken objection, didn't know whether Mr. Lee was gay, but had taken objection to the message on the cake, the message support gay marriage. And because it was a political case, she realized that she thought probably Mr. Lee supported this political message. Anyway, we won on all grounds in front of her. The case was appealed to the Northern Ireland Court of Appeal, and we won on all grounds in the Northern Ireland Court of Appeal as well. At that stage, the Attorney General for Northern Ireland intervened. And there's a whole side story about this case, about the role of the Attorney General, which I don't have time to go into. But then the case was appealed to the Supreme Court. Now, by then, a whole bunch of interesting political things had happened. The first, which is a fascinating footnote to this story, was the decision of the judge as to when to give judgment at first instance. And initially, she had thought she would give judgment on the day of the general election in whatever it was, I suppose, 2014. And there was opposition about that, because it was said that her judgment could actually sway the outcome of the election in Northern Ireland. It might cause the Protestant community to come out in greater force, or it might cause the Catholic community to come out in greater force. That seemed to me quite possible because I managed to unite Catholics and Protestants in Northern Ireland in opposing my client's interests. Anyway, she decided in the face of opposition to put off giving her judgment. Now, whether by design or not, I don't know, she did choose a rather significant day in which she did give judgment, which happened to be the day of the referendum in the South, in the Republic of Ireland, on the question of gay marriage. And it's something of great interest to me that for many reasons, not just this judgment, the referendum in the South led to a change of the law there, when the community in the South said, yes, we must change the law and permit gay marriage. So whether it was of significance there, I don't know, but I suspect it might have encouraged one or two people to turn out on the referendum on that day. Anyway, that was one political thing that happened. Second political thing was it split the gay community. And there are several leading members of the gay community who thought that this was actually an attack on freedom of thought. I think they are very badly wrong about their approach to this, and I'll explain why in a minute. But some leading commentators from the gay community came out in support of Mr. and Mrs. MacArthur and Ashers. And it was not helpful, frankly, that they should have done so. In due course, the case came up to the Supreme Court. And the impression I got from the very beginning was that the judges on the Supreme Court hated my case. I've done over 40 cases in the House of Lords and the Supreme Court, and I have some antennae to read the court. I don't always get it right, but it did not feel as if they wanted to listen much to what I'd got to say. Hey ho, I lost. The case is not yet over because it's currently in front of the European Court of Human Rights. And it will be an interesting route. We'll see whether the court is engaged with it or whether they think it's just a case about a cake or not. But I'm going to tell you why I think the case is important from my point of view. The way it was decided in the end was to say that Mr. Lee could not complain about sexual orientation discrimination because the bakery took issue not with his sexual orientation, but with the words gay marriage on a cake. And it was said there was no protection of the message. I personally think that this is casuistry. And I think I have to say that it was driven by a very carefully constructed presentation of Ashers as being kind of good, upstanding people in the community, which no doubt they are, and that this was somehow oppressive of them. Let that be for a moment. The reason that we were said to have lost what was the political opinion discrimination is much more dangerous, because the essence of it is that we were able to demonstrate that nobody would have known that Ashers was a religious bakery, that the cake could have been wrapped up in many different ways without anybody knowing that it had come from Ashers in any particular way. Nonetheless, the Supreme Court concluded that it was enough for Mrs. MacArthur to have the fear that that could happen. Now pause to think about that for a moment. My own personal view is this: commerce is the best possible way to bring communities together. In commerce, people buy and sell goods from people that are not like them. Black people buy from white people from black people, Christians from Muslims, Muslims from Buddhists, Buddhists from people of no religion at all, and it's all mixed up together, and it brings people together. But the message that the Supreme Court have given in this judgment is that a person with a legitimate political point of view, one so legitimate that it's now been adopted in Great Britain and indeed ultimately in Northern Ireland, as well as the South, can be refused service in a context in which they know nothing about the religious views of the people from whom they're buying goods. That cannot be right. Commerce should be free and without any discrimination. So that's the key to my view about this particular case. And secondly, and this is really important as well, this is a case about conflicts of rights, just like Bull and Bull and Hall and Preddy. And as it happens, the legislature, Parliament, had said that people should not be able to discriminate on religious grounds unless they're actually part of a religious organization. And I regret to say the Supreme Court simply ignored that. And I think this judgment is therefore a challenge to a democratic process in which a legislature had sought to resolve, with full knowledge of the human rights issues, a very difficult conflicts of rights issue, and had done it with great sensitivity after great engagement, and with the Joint Parliamentary Committee on Human Rights saying that it had approached it in an appropriate way. So we'll have to watch and see what happens. Thank you.
Fantastic. Thank you, Robin. Sorry, you caught me a little unawares there. You stopped suddenly. How interesting. And everyone's giving you a virtual round of applause. So thank you very much. Who could imagine there could be so much to a cake? And in thinking about it in terms of commerce, particularly as a commercial lawyer myself, I find a very interesting way of thinking about it. So given me particularly much food for thought, as opposed to cake for thought. Right, without further ado, I'm going to hand over to our last, but certainly not least speaker, Raza Hussain. Raza, thank you so much again for joining us this evening. I know you had a difficult journey home, so we do appreciate very much you managing to make it here this evening. So can I hand over to you without further ado? Thank you.
Thank you very much, Penny. Thank you very much for inviting me. I'm very happy to be here. I'm going to be quite brief because, as I understand it, we're on until about 7:30. And you wanted to leave time for questions. So I'm going to be about 8 minutes or so, which is, I think, what Diana, you'd suggested. So I'm going to talk about myself for a minute, which, again, Diana, you'd said I should do. And then I'm going to talk about H.J. Iran. So I went to a state school in North London. I was the first person in my family to go to university. I didn't know what to do at the end of my degree. I didn't do a law degree. I wanted to work for Amnesty International. I was told by a sort of absolutely wonderful careers officer at university that law could make a difference to society, which is what I was interested in. I went into law to do immigration and anti-discrimination law, so I had heard of Robin. I did some outdoor clerking work for some really sort of extraordinary immigration solicitors, David Burgess, widely regarded as the best immigration solicitor of his generation, who's sadly no longer with us. And then I was called to the bar in 1993 and did my pupillage at Two Garden Court, which was a very well-known immigration set. I was very lucky there to work with Ian MacDonald, QC, who was the leading kind of immigration light, and then Nick Blake, QC, also very much a leading light later, Mr. Justice Blake. I moved to Matrix in 2000 and again was very lucky to work with people like Ben Emerson QC, who many people think, and I agree with them, was the greatest human rights barrister of his generation. Rabinder Singh QC, and then Mike Fordham, Mr. Justice Fordham now, He was at Blackstone's, but I was lucky enough to do a lot of work with him. So I was very lucky to have these mentors. Mentors, very, very important. That's how you learn. As Robin was saying, you continue. It's a continuous learning experience, which is, I find very great. I had a lot of support from my family, and I certainly wouldn't be here without them. You wanted to say that. Before I move on to HJ, I just want to say a couple of things about the Guidan case, which Paul talked about. It's a spectacularly important case. I completely agree with him, and for two reasons, other than the ones that Paul talked about. Firstly, it concerned socioeconomic rights, where the courts generally tread very, very warily because they think, well, we lack democratic accountability, the legislature does, and so we're going to leave it to Parliament. And it's a very, very important case about how the deference that would ordinarily be due to balances struck by the legislature is conditioned and narrowed when you have discrimination against a minority, which is obviously a basic function, if you think about it in sort of political theoretical terms, a basic function of any of the majority. The second reason it's really important is because of what it says about the Section 3 of the Human Rights Act. This is the interpretive rule, and it established that you didn't need ambiguity, and it drew the analogy between an EU law principle of interpretation in Marleasing, which is a very, very strong and robust principle of interpretation, and Section 3. So it was very important for those reasons too. And it's got some of the most extraordinary passages you'll find. Repays careful reading from Lady Ho. So H.J. Iran. So this is a case that established that a gay person is a refugee if in their home country they would be persecuted if they were openly gay. So far, so obvious. The innovation in HJ was that is the position, they're a refugee, even if they wouldn't be openly gay. If one of the reasons why they wouldn't be openly gay is the fear of persecution. And that was a dramatic change in the case law. And the reason it was a dramatic change was because when I started practicing in the 90s, the prevailing view in refugee law, there was an expectation, the prevailing view was that a claimant could be expected to exercise reasonable restraint, quote unquote, and avoid persecution. So despite the fact that what was unreasonable by any standard was the fact that the persecuting state would be behaving as it was, nevertheless, the prevailing view was no, it was up to the individual to take reasonable steps to keep out of harm's way, a sort of self-help remedy, if you like. And the innovation in HA, as I said, was that even if you were going to avoid the persecution because you had no desire to be a martyr, you were a refugee if you would be persecuted on the hypothesis of openness. And the way the Supreme Court got to that was to find a right in the Refugee Convention that individuals were entitled to live freely and openly without fear of persecution in accordance with their protected characteristics. What do I mean by protected characteristics? Well, the Refugee Convention says that you're a refugee if you would fear persecution for reasons of race, religion, nationality, political opinion, or membership of a particular social group. And it's been long established, well, last 20 years, that gay people are protected because they form a particular social group. This is an example of a living instrument approach to a fundamental human rights instrument. Homosexuality or sexual orientation is not a protected ground explicitly in the Refugee Convention. It dates from 1951, but almost universally, it's now accepted, has been for about 20 years, that gay people are protected because they form a particular social group. And if they're protected, they're entitled to be who they are, freely and openly, without fear of persecution. A lot of the argument focused on the Anne Frank principle, or the Anne Frank example, given the genesis of the Refugee Convention in the aftermath of the Second World War. And the argument was basically assume that she would have been safe in the attic. Tragically, of course, that wasn't the case. Was she a refugee on that assumption? Of course she was. She had a right to be open about her religious and racial Jewish identity and to be free of persecution when expressing that identity. The persecution clearly wasn't her being locked in the attic, which is essentially what the government's position was. I'll come back to that in a minute. The persecution was what would happen if the Gestapo found her, the gas chamber. The government argued that in these sorts of circumstances where the individual would take self-help, would suppress their protected identity to avoid persecution, they could only be a refugee if the internal impact of that suppression was so intolerable so as to cross the threshold of persecutory harm. And the Supreme Court dealt with that very briefly. It was the dominating view in the English Court of Appeal for at least 6-7 years, from about 2003 to 2010, which is when HA was decided. And the Supreme Court said, well, how on earth do you measure what's intolerable in those circumstances? And secondly, it requires you to prove double persecution. It requires you to show that if you were out, you would be persecuted, and the fact that you're not out, you're suffering such intense harm that it amounts to persecution. So, very important case, memorable for many reasons, but perhaps most memorable for what Lord Rogers said about what it is to be open and free. And he said this, I'm just going to read the famous passage out, paragraph 78 of his judgment. In short, he said, what is protected is the applicant's right to live freely and openly as a gay man. That involves a wide spectrum of conduct, going well beyond conduct designed to attract sexual partners and maintain relationships with them. So he counseled against a reductive view of a narrow and austere view of sexual identity, homosexual identity. To illustrate the point with trivial stereotypical examples from British society, just as male heterosexuals are free to enjoy themselves playing rugby, drinking beer, and talking about girls with their mates, so male homosexuals are to be free to enjoy themselves going to Kylie concerts, drinking exotically coloured cocktails, and talking about boys with their straight female mates. Mutatis mutandis, and in many cases, the adaptations would obviously be great. The same must apply to other societies. In other words, gay men are to be as free as their straight equivalents in the society concerned to live their lives in the way that is natural to them as gay men without the fear of persecution. So it's a very catching, striking example. I think the point of it was to underline what I was saying a moment ago, that you can't look at what is involved in being open and free in a reductive, narrow, or austere way. I just want to make two further points about this case. Firstly, I think very much it's the case of its time. As Penny has said, as Catherine says, as Robin has said, it was clear from the opening remarks of Lord Hope that by the time the case was decided, homophobia was absolutely anathema as far as the Supreme Court was concerned. That obviously wasn't the case 10, 20 years before that. The second point that I wanted to make was that I perhaps have the naive view that minorities should stick together in a kind of the broad sense and understand and empathize with each other, realizing they've got more in common than not. And indeed, that's the position generally, I think, with people. But in that regard, it's important that HJ Iran has been used in the refugee context to inform and expand refugee protection for people fearing persecution on the basis of their minority religion or a minority political opinion. So short of about 2 years after HA was heard, the Supreme Court heard the case of RT Zimbabwe, where the issue was could an apathetic individual facing return to Zimbabwe, someone who didn't care about politics, politically apathetic claimant, could they be expected to lie and profess support for the Zimbabwean regime at the various checkpoints that existed at that time? And the Supreme Court very emphatically said, no, they couldn't, because they, just as the right to have a political opinion is protected by international human rights law and the Refugee Convention, so is the right not to have one. And if you think about it, pluralism is absolutely critical to democracy. And the Refugee Convention was enacted in the aftermath of one totalitarian regime and just before another, Germany and Russia. And the hallmark of totalitarian regimes is they require not just support, but absolute adherence. And neutrality is anathema to them. So it's sort of generated a lot of really important case law in the refugee field. That's all I'm going to say. And hopefully that's enough time for questions.
Oh, Raza, thank you so much indeed. That was really interesting, very insightful, and I think a lot of people have got a lot from that talk. So again, thank you all very much. It's kind of metaphorical virtual clapping. I do apologise. I'm going to hand over to Diana now, who's kindly offered to curate Q&A. I hope people will bear with us and accept that we probably are inevitably going to run over time, and do understand if someone has to leave, but it's a really good opportunity for people to ask questions, and I know we've got some comments. And anyway, Diana, over to you. The floor is yours.
Thank you, Penny, and thank you to all our speakers. How incredibly interesting. So this isn't really a question, but I wanted to mention it. So Russell Conway, thank you so much for coming to our talk and for commenting. So obviously you were the solicitor in the case of Mendoza, and it's really interesting to see what happened. I'm not sure if everyone else can see the comments. If not, I'll read it out. So apparently the landlord was so desperate to get rid of him that he paid him £450,000, goodness, to surrender the tenancy. And he went off to buy a farm in Brazil. Okay, all right. So kind of, I suppose, a happy ending. That's very interesting. Let's have a look at the other questions. So I can see a question from Liz. Hi, Liz. So she's got questions for Catherine. So firstly, would your clients have brought the claim knowing what they did by the end of it? You're on mute, Catherine.
Kath, you're on mute.
Sorry, on mute and lost my cursor. I mean, I have to say, it's not something I've asked them, and I do know that that Steve doesn't actually like to talk about the case very much. Having said that, I think knowing what the case did and how important it was, and particularly when you look at some of the things the Supreme Court said, particularly Lady Hale, I suspect that they would still bring it. I think that they would probably. I think what they would perhaps have wanted was to be a bit forewarned about the impact and what might happen. I think perhaps one of the things was that they weren't prepared, and perhaps the Commission at that stage wasn't prepared for the ramifications. But when you look again, and I think there's an element to all of these cases of this, at some of the things that were acknowledged in a judgment. So you look at what Hale said about not underestimating the continuing legacy of centuries of discrimination, persecution, even of gay people. Then to have that in a judgment, that's really important. And knowing them the bit that I do, I don't really think that they would have said no, not to bring it, because if they weren't going to, then I don't know who. Yeah, I don't know if anyone else would have been the right people to do it or in the right circumstances at that time.
Thank you. And then another question for you, Catherine, from Liz, is what advice would you give to aspiring students who are like you from a non-legal family background?
Well, I mean, I think if you can to do volunteer work and pro bono work, I think that's ideal. I mean, I know that's difficult because people are juggling, trying to work at the same time as juggling their student lives. But that's the ideal. And sometimes it's not even if you're not able to do pro bono work in a legal context, it's doing pro bono work for an organisation, for example. So there's a lot of value in a campaigning organisation, for example. And sometimes you can bring your legal skills to that.
Thank you. And it's really great that you've said that, because obviously I'm always encouraging my students to do pro bono, but it's lovely to hear that from you as well. Okay, Sophie's asked a question. I'm happy for anyone to take this question. She said, so judges from time to time mention public opinion in judgments, but how do you know what public opinion is at any given time, and do you think it's ever a valid argument in support of a judgment? So I don't know if anyone in particular wants to take that question.
I have a shot.
Go on.
If you hear judges talking about public opinion, it's a big red flag. I never go into court now, and haven't done for 30 years, without knowing everything that it's possible to know about the judge I'm appearing in front of. I will look them up. If they've got a Wikipedia entry, or if it's possible to look them up in Who's Who, to find out everything that it's possible to know, where they went to school, what clubs they belong to, who they support, what books they read, anything that you know. The truth is, there's no such single thing as public opinion. There's what newspapers tell you is public opinion, or what focus groups tell you is something that plays well, but it usually is the refuge of a judge who can't think of an argument based on a legal premise that is going to try and do you down in some way or another. I bet actually Raz's had probably more than enough of this over the years. I've certainly had masses of it. Judges tend not to try it on with me now, but because it gets me pretty wound up usually. But anyway, I'd like to hear what the others say. I was just an intro.
Thank you. Oh, sorry, go on, Raza.
Yeah, I mean, I agree with Robin. Stephen Sedley, one of the great judges of modern times, former colleague of Robin's, one of my inspirations and mentors. He is, I think he talked about how you couldn't equate public opinion with the baying of the tabloids, quote unquote, in a case, I think it was a case called Velino, about 20 years ago. I agree. I think it's obviously one of the really hot topics at the moment is immigration and human rights, in particular family life. And what's very interesting is that that's been sensitive from very early on. And the Bingham Court, Lord Bingham's court, again, one of the great judges, if not the greatest judge in the modern era. I had the sort of privilege of appearing in front of him many, many times as a junior. He never had recourse to public opinion considerations ever. And that's not the position subsequently. In subsequent cases decided on the same issue after governmental attempts effectively to overrule his judgments in the late 2000s, there has been recourse. And I think for myself, I think that's questionable.
Thank you so much. I've got another question from Midapa. I think I know the answer to this question, but anyway, I'll ask it anyway. Would any of the panelists choose a different area of law, given the difficulties they've faced in all their cases?
Well, it's a one-worder from me. If you go into law as a barrister, you should thrive on difficulty and back your judgment. And I've certainly gone, as all the panelists have, backing my judgment and dealing with adversity. And I've loved it. So the short answer is a big round no.
Can I say something on this? Unlike the other three panelists, I haven't been a human rights lawyer. And nonetheless, it was a very enjoyable career. You started looking at the papers, you got an idea, you followed it, you developed the arguments, you went for a walk, you thought about it, and it was absolutely exciting. And for a young person, or not so young person, because many people of my generation came to the bar in their late 20s or early 30s and had perfectly successful careers, having come a little bit later. It was very exciting. It was great fun. And honestly, I can't think of better company than fellow lawyers. After the case, you're good pals. You go and have a chat, cup of coffee these days rather than the beer. And yeah, it doesn't really matter which field you're in, as long as you pursue it with enthusiasm.
Thank you so much. And Martha and Catherine, I'm guessing, do you agree with that? Are you happy with the area of law you chose?
Yeah, passionately so. Absolutely. Can I just come back on something that Catherine was saying? I think it's really critical in terms of access. It's really critical for people, if they don't have contacts in the profession, to develop them. And the way you develop them is by doing voluntary work. And if you can get paid work, all the better. But you know, I wrote blind letters to people like David Burgess at Stanley Burgess, Wesley Grick and Nigel Leskin at Bernberg's, and you know, I had the incredible good fortune that they answered my kind of blind letters, and I worked with them when I was very, very young, and that was incredible because you saw the best people doing their job. It was quite intimidating. But it is really important to do. There's no substitute for experience. You get a sense of, do you like the area? Do you like what's going on here? It's very important.
Thank you. You're doing my job for me. Brilliant. And then I think this is the last question from Anna. Oh, it's not the last question. Hi, Anna. So her question is, do you think it's possible to strike a balance between religion, belief, and sexual orientation under the law, or will one always win over the other? And so she's thinking in particular about the No Outsiders campaign in Birmingham. So does anyone want to take that question?
Maybe that's me. I'm not going to talk about the No Outsiders in itself. I'm going to talk more generally. One of the things you will learn early on if you study human rights law, and in particular equality law, is that no one human right, it trumps always every other right, that there's not a hierarchy. But whenever there's a loser in a case in which there's conflicts of rights, the losing party always says, oh, my rights have been thrown away, they've been trumped in some way or another, and they miss the point. The point is that actually all the human rights work together. And that does mean sometimes things that are really precious to us, we have to put to one side because others have got in that context different kinds of rights which are judged in that specific context to work out. And in conflicts cases, the really interesting question is whether this is to be done by judges and lawyers, or whether it's to be done in a properly informed democratic process. And when I say properly informed, one in which people try to draw a balance which brings together everybody's human rights and respects them all. So in some places, the law has done that. In others, it ignores it. I mean, Raza's example of Iran is a case in which the democratic process simply ignored the rights of gay people, and he had to be the advocate for them. In Lee and Asher's, actually the law had tried to draw this balance and had gone through a process in Northern Ireland, a very long process in looking at the way in which political opinions could be respected in a highly religious community. So it's a tricky one, but it is context specific. It's also engages with the democratic process.
Thank you. And I'm really mindful of time, and thank you everyone for staying later the night that I asked you to. One more question. Or not. Okay, all right. No, it's true. It's already 20 to 8. So in fact, we won't, okay. I will hand back to Penny then, who can sort of wrap up for us. But thank you so much. I really appreciate you staying so late.
Yeah, no, we really do. And maybe we might be able to discuss further outside of this, because one of our students did ask a question on sort of the future of LGBT rights. So perhaps we should bring this forward as a kind of LGBT history too. Anyway, I'm so grateful to all of you, Paul, Catherine, Robin and Raza, for so generously giving up so much of your time. The fact that we had so many of our students and colleagues from the school and indeed the broader university on this shows how much interest and how important these cases have been and will continue to be in the future. And I think each of you is in a different way has both shone a light on, brought those cases into that kind of contextual sense that can sometimes be difficult to see from just the reading of a judgment. But also I hope that you might be inspiring a new generation of lawyers who will see the importance of working, not necessarily for huge sums of money, enough to keep us going is important, but we'll recognize that the law is about far more than just remuneration, but is about helping people in a day-to-day context. And that's something we try to instill very much so. So I would just like to conclude by thanking everyone and thanking all of the participants who joined us this evening. We're delighted to have so many. And this has been a wonderful contribution to LGBT History Month. And Diana, we are eternally grateful to you for having the wonderful idea in the first place. So if I could ask everyone, please to give a loud, as loud as you can, because you can't, I think most people are muted, but virtual round of applause for our speakers. And thank you all so much indeed. Thank you. There we are. Absolutely wonderful. And there is a recording of this, so people can watch this afterwards. So I'm sure that many of our students will continue to do so. Robin, we wish you all the best of luck on your Caribbean island. I do hope you'll be ready.
Come and join me.
Oh, I'd love to.